Welcome back to Winning Isn't Easy. Sometimes court cases will read like mystery stories, horror stories, and fairy tales. So I'm going to tell you a fairy tale story of the senior business analyst with MECFS who was awarded their own occupation benefits. Now, it's not unusual for disability carriers like Aetna to deny an MECFS claim on the basis that even reported abnormal tests don't represent an illness of a severity to preclude the policyholder from doing their occupational tasks. That's typical language that I'll see in a claims denial. Or they'll say, there's a lack of clinical findings. Or they'll say, look, the activities of daily living, like walking or doing exercise, are activities that are in excess of the functional requirements of your own occupation, particularly if you are engaged in a sedentary occupation. So I want to tell you the story about how one federal judge educated themselves about MECFS claims and relied on the CDC guidelines and medical research to overcome a wrongful claims denial. As I've said, it's hard for an MECFS long-term disability policyholder to get their benefits because the carriers often improperly require objective evidence of the diagnosis, and that can be hard to obtain in an MECFS case. But even if you produce that objective evidence, the carrier is going to say, well, wait a second. The activities of daily living are inconsistent with their complaints and the level of physical functioning their occupation requires. And that's exactly what happened in the case of DeVires versus Aetna Life, which is a California case that came out in June. Now, DeVries was employed by First American as a senior business analyst, and that's a sedentary job. But there's a lot of cognitive requirements of that job or occupation. Now, DeVries suffered from chronic fatigue, weakness, body aches, upset stomach, headaches, all the classic symptoms of MECFS. And ultimately, she was diagnosed with MECFS, and her doctor said, look, we want you to stop work, and we think you should apply for benefits, and we'll support your claim. So she did just that. She applied for her benefits, and Aetna referred her case to PDA, a well-known carrier, favorable medical vendor, a stable of liar-for-hire doctors. And they, of course, assigned her file for an endocrinological peer review by Dr. Robert Cooper. Dr. Cooper concluded that the lab testing was essentially normal and that her reported symptoms and examination findings just didn't support her diagnosis. Now, you would think that they would have had her file reviewed by a specialist, not an endocrinologist. But that wasn't good enough for them, so they referred her file to another infamous outside medical vendor, Reliable Review Services, who reliably reports that people are not disabled. And their reviewer, Dr. Abbott, said that, look, this file does not support a finding of functional impairment. Her subjective complaints are inconsistent with the activities that she reported on her ADL form. Now, I want to point out that as this is going on, DeVries is being paid her long-term disability benefits through her private disability insurance, and Aetna ignored the same and just stuck their nose up in the air. So when her claim was ultimately denied, she filed a lawsuit, and the court found that she had submitted numerous laboratory tests with abnormal results. Her physicians had noted those results in opining that she had restrictions and limitations that prevented her from doing her occupational duties. And the federal judge took notice that according to the CDC, MECFS is a disabling and complex illness, noting that researchers had not yet found what causes MECFS and that there was no specific gold standard laboratory test to diagnose it directly. But the judge noted that the doctors needed to consider that diagnosis based on an in-depth, in-person evaluation of a person's symptoms and medical history, and that it was important that the doctors diagnose and treat any other condition that could cause similar symptoms. The judge noted that according to the CDC literature, that patients with MECFS could have illnesses resulting from different causes, and that there could be two or more triggers that would cause the illness. So a person, for example, could have an immune system change. They could have stress affecting body chemistry. They could have change in their energy production. They could have infections. They could have possible genetic links. And the court also noted that 1 in 10 people who became infected with Epstein-Barr developed a set of symptoms that met the criteria for ME/CFS. The court noted that there was a possible link between T-cell irregularity and ME/CFS. The court noted that there was a possible link between glandular issues and the hormones that they release, including cortisol, and that in an ME/CFS case, that you couldn't simply rely on the cortisol levels to diagnose or treat the ME/CFS. The judge took notice that Aetna was asking for objective evidence of the chronic fatigue syndrome ME/CFS diagnosis. And the court said, look, when I look at all the evidence, when I look at the CDC criteria, I think by a preponderance of the evidence, she suffers from clinically evaluated, unexplained, and persistent chronic fatigue. The court found that her doctors were more reliable witnesses than the tier 2 peer review providers, because to properly diagnose the chronic fatigue syndrome, you had to have, as I said, a careful examination of the patient, a review of the patient's symptoms, and a good medical history. The judge found that her doctors had interacted and examined with her over the course of a lot of appointments, and that they were in a far better position to make a determination than the peer review doctors. And the court went on to say, look, she's unable to perform the substantial and material acts necessary to do her occupation as a senior business analyst because not only did it require physical activity, but it required analytical, strategic, and managerial tasks and skills. And guess what? Aetna had blown past those tasks. So the court said, look, I'm going to overturn this denial. I'm going to award these benefits. And in my view, it was a wonderful result. It was great to see a judge who took time to not only review the medical file, but to review the medical literature and consider that literature in analyzing the adjuster's conduct in denying this case. So what are the lessons learned? The lessons learned are that the court will consider medical literature and material from agencies such as the CDC, that the court won't require objective evidence for a diagnosis for a medical condition like CFS and migraines that aren't typically characterized by objective evidence, and that the court is going to look for a careful physical examination of the policyholder, a good medical history, the elimination of other causes for the diagnosis, and consistency not only in the medical records, but in the statements of the policyholder. Wow, what a decision. Well, that wraps up our podcast today. I hope you've enjoyed our podcast and that you'll subscribe to the show, leave a rating or a review. Talk to you next week. Take care.